This video is called the Private Guardian Ad Litem, or PGAL, scam. Are you a parent involved in a Utah child custody dispute with the children's other parent? If so, do you believe it would be helpful for the judge to know how your children feel about their relationship with each of their parents, what they've experienced over the course of their lives in the custody of one or both parents, what they've observed, what opinions they have, and what kind of custody award and schedule they would desire? Of course you do. Why wouldn't you? And have you been told that the best way to ensure that the court knows about your children's experiences, observations, feelings, opinions, and desires is by having a guardian ad litem, or GAL, also known as a private guardian ad litem, or PGAL, appointed for them? And have you been told that a guardian ad litem is a lawyer who is appointed to represent your children, to protect their interests, and to give them a voice regarding child custody award matters? If so, have you believed what you've been told? Don't. I will explain why. Section 78A-2-803 of the Utah Code provides in Section 1, quote, A, the court, Romanet 1, may appoint an attorney guardian ad litem to represent the best interest of a minor involved in any case before the court, and Romanet 2, shall consider the best interest of a minor consistent with the provisions of Section 80-2A-201 in determining whether to appoint a guardian ad litem. And then there's subsection B. Quote, in all cases where an attorney guardian ad litem is appointed, the court shall make a finding that establishes the necessity of the appointment. A PGAL is rarely, if ever, useful or of any real value because a PGAL is not a source of any admissible evidence or facts. This is because a PGAL does not assist the child, the parents, or the court in learning any facts pertinent to the circumstances bearing upon the child custody award, and also the best interest of the children. How is that possible? Well, believe it or not, a PGAL cannot respond to discovery requests. A PGAL cannot testify on behalf of his or her client or clients. None of the PGAL's interviews of the children or anyone else the PGAL may speak to in the course of the PGAL's investigation are on the record. All that a PGAL can do is make recommendations. See Utah Code Section 78A-2-803-12A. When the PGAL is not an expert in anything, much less an expert in child development, psychology, or child custody, what good is the recommendation? A PGAL's recommendations are based upon no materially greater expertise, if any, than the judge himself or herself possesses. A PGAL is by design not the source of any admissible evidence. If the court wants access to admissible evidence and to gauge the credibility of the respondent's allegations or the petitioner's allegations solely based on hearsay, what is needed is the testimony of the party's children on the record. Given the statutory limitations on what we can know of what a PGAL does, the court does not need a PGAL, indeed cannot utilize a PGAL to find out what the children have experienced, how they feel and why, what the children want, and whether their desires support or do not support particular custody or parent time awards or modification of the child custody and or parent time award that currently exists. If a PGAL did that, the PGAL would be proffering inadmissible hearsay and violating the confidentiality of attorney-client communications. The only ones who can admissibly tell the court these things are the children themselves, assuming they can speak, of course. The court can and should learn these things itself directly from the children themselves. Isn't that obvious? Appointment of a GAL or PGAL is, in the overwhelming majority of cases in which they are appointed, and I'm just going to go through a couple of bullet points here, inferior to obtaining the testimony of the minor children on the record through an interview by the court, and frankly, a mockery of an impediment to a trustworthy and just fact-finding process. All that a PGAL can do is make recommendations that, by law, see Utah Code 78A-2-803, have no foundation in any facts in the record. The way Utah law governing GALs and PGALs is structured, a PGAL could literally never speak to the children and then lie to the court and to you and claim that the PGAL did so anyway and then make recommendations based upon nothing. And there is practically no lawful way to prove it. PGAL recommendations are thus inherently suspect and ask the court to exercise faith instead of examine facts. A GAL or PGAL and his or her files are not subject to discovery. The best shot one has of so much as trying to obtain PGAL files requires a subpoena from the Utah State Legislature. It gets worse. The only way to know whether a child's wishes differ from those of his or her guardian ad litem is, can you guess? Through the guardian ad litem, not the child himself or herself. Can you imagine such a policy applying to anyone else involved in a civil suit? For example, I, the lawyer, forbid you from questioning my client, even if the client is able and or willing to testify, as to whether his wishes differ from what I say they are. I'll just tell you, secondhand and in summary form, no less, no more, myself, what I say they are. That's crazy. It's patently irrational. While Utah Code Section 78A-2-803D provides, quote, the guardian ad litem shall disclose the wishes of the minor unless the minor, Romanet 1, instructs the guardian ad litem to not disclose, that's a nice split infinitive, the minor's wishes, or 2, has not expressed any wishes. The only way to know any such things, however, is from the child himself or herself, not an intermediary who makes claims that aren't verified. A difference between the minor's wishes and the attorney's determination of best interest may not be considered a conflict of interest for the attorney. That is literally what the Utah Code provides. The sentence to which this footnote is associated is a verbatim quotation from Utah Code Section 78A-2-8038C. Now, if a GAL or PGAL were to attempt to purport to tell the court what his or her child client said, it would be both hearsay and would violate privilege in the confidentiality of communications between attorney and client, and would entitle the other parties to call out of court the purported hearsay by having the declarant, a witness, examined on a statement as if on cross-examination, meaning that if the PGAL says, this is what my child client said, you could then cross-examine the child. A PGAL is not an expert witness, and that's been established by Utah law and case law. Although the statute requires the GAL to make recommendations to the court, it does not suggest that those recommendations are to be treated as evidence. I don't understand. I mean, you can see Utah Professional Conduct Rule 3.7 that prohibits an attorney with limited exceptions from acting as advocate and witness in the same trial. To delegate the gauging of a child's credibility to a PGAL would be impermissible delegation of judicial authority on top of that. Under Utah law, a PGAL can literally lie about the interviews the PGAL conducted of the children, or even conduct no interviews at all, but lie and claim to have conducted the interview just the same, and make recommendations based upon pure fiction and or anything but the child's experiences, observations, feelings, opinions, and desires, but instead make recommendations based upon the PGAL's own personal biases and prejudices without anyone ever being able to verify whether the PGAL engaged or did not engage in such misconduct. That constitutes a denial of both procedural and substantive due process. To permit a PGAL to make recommendations without there being any record against which to verify the facts upon which the PGAL ostensibly bases his or her recommendations is self-evident and indefensible evidential failure. Don't get the witness's direct testimony on the record, so the argument goes, take my second-hand word instead, is not how fact-finding works. It can't work that way. The obvious rhetorical questions surrounding the inherent incompetence of the PGAL recommendations process are unavoidable in child custody cases. 1. Why have someone else speak for the child who is able to speak for himself, and B, willing, often eager to speak for himself? 2. How A, is a child, particularly a child over 12 or 14 years old, shielded from any harm? B, is a child's best interest served by silencing his or her voice in the proceedings when he or she has a greater stake in the proceedings than anyone else? 3, how can anyone argue an intellectual honesty, and the argument gets made virtually every single time it is proposed that a child be interviewed by a court, that having the court interview a child, quote, puts the child in the middle of a legal dispute, close quote, or, quote, involves the child too much in his or her parents' legal dispute, close quote. And yet argue in the same breath that having a DCFS caseworker, for example, and usually a law enforcement officer, or a GAL, or a therapist, or a counselor, or a custody evaluator, interview the same child, 1, does not put the child in the middle somehow, and 2, then make a non-record, factually unsupported summary, report, and a recommendation, not only make good sense, but may even be a moral imperative in the child's best interest. How can anybody claim that? Number 4, why substitute a child's testimony for a GAL's recommendations when the child can speak directly to the finder of fact on the record? Number 5, how can a child being interviewed by, for example, a DCFS caseworker, and usually a law enforcement officer in the bargain, a GAL, a therapist or counselor, or a custody evaluator, be so routine and deemed so harmless to children, or at least justifiable, regardless of what, if any, harm it may cause a child, but being interviewed by the court can be deemed otherwise? It can't. In intellectual honesty, it can't. The legislature empowers courts to interview children already. See Utah Code Section 3-30-3-10, sub 5. The average qualified GAL is, but for a few hours of training, no better at questioning a child than a domestic relations commissioner or judge, which is a distinction without substantive difference. Any commissioner and any judge who is qualified to decide the custodial fate of a child who is competent to testify and is qualified to interview that child should do so. And if a court felt it could benefit from GAL training, the Utah Office of Guardian ad litem offers the training to judges and commissioners free of charge. There's no excuse for a judge or commissioner claiming that he or she is unable or unqualified to interview children. Indeed, whether a PGAL or custody evaluator or other similarly situated third party were involved in a child custody case involving children who are capable of testifying competently, one of the best ways to gauge the children's credibility and to learn of their experiences, observations, feelings, opinions, and desires, and to get an understanding of what the children need, is for the commissioner and or judge to interview the children directly, from their mouth right to the judge's ear. Indeed, the only evidentially sound way to ascertain a child's desires regarding custody is by including in the court's analysis the on-the-record testimony of the child on the subject, not a summary, second-hand hearsay recommendation. Interviewing the children one-on-one costs the parties nothing, takes far less time than a PGAL takes. A good, complete interview of a minor child by the judge or commissioner usually takes less than an hour to conduct. And an interview by the court is unfiltered, unsummarized, unadulterated, on-the-record testimony of the child. It's in response to the questions the court considers material and relevant, and, as I said before, direct from the child's mouth to the court's ear. An interview of a child by the judge or commissioner is in this situation, frankly, superior to the limited functions of a PGAL. There is nothing a PGAL can do to interview the children that the judge cannot do. The difference being that a judge's interview of the children is unfiltered by bias and observational oversights and or biased, it's unsummarized, and it's on the record, so it keeps everybody honest, and that includes the judge. A judge's interview is patently superior to a PGAL's interview, if it even takes place at all. Even if the court can see and articulate some genuine value in a PGAL, the judge should interview the children regardless. That way, at the very worst, we have 2 points of data available to the finder of fact, one of which is on the record, so that the court can compare what the children tell the judge against the PGAL's recommendations. Appointing a PGAL is not the best temporal, economical, or evidential course of action when the court can instead interview the parties' children for and on the record. The better course of action is having the judge interview the children on the record. To read about why, click here for that blog post, which I've provided in the video description.